Okay. So moving on then to the last section of the work that we need to do for the semester, namely partnerships. Partnerships forming a big part of the semester, a very important part. There's also certain aspects of partnership law which is compulsory prior knowledge for you to be able to do companies next year. That's why even if you've passed commercial law 1A and B, you do not get exemption from introduction to law for accountants. Let me share my screen. Okay, can you see that? Give me a thumbs up. At the moment, it's just a blank page. So, partnerships. You're all in the accounting business. Many of you, if not all of you, already work in accounting firms. So you have obviously already come across the term, the concept of a partnership. You might think, and you won't be too wrong, but you won't be entirely correct. If you think of a partnership as a business, another type of business, like you get companies, you get close corporations, you get partnerships. Think about a partnership. If that is your understanding of a partnership, fairly accurate, but not 100% correct. I'm going to be teaching you some things about partnerships that you perhaps don't know at this stage. Let me firstly give you an example, something that you probably don't realize. Let's say, I'm going to try pronouncing her name now. If I say it correctly, give me a thumbs up. Waririra, is that correct? Waririra and Hedvig want to go on a trip together, but they don't have money to go on this trip. So they decide, well, let's make some money. Let's sell sandwiches on the NUS campus. And they each put in $200. They go walk down to Vernil, buy some bread and cold meat and margarine, whatever, make some sandwiches, go around campus selling their sandwiches. There's always hungry students around. At the end of the day, they end up making $1,000. And Waririra keeps 500 and Hedvig keeps another 500. That's it. They don't, no fancy offices, no whatever. Did you know? Give me a thumbs up if you knew, if you realized that this situation that I've just described, Waririra and Hedvig putting money together, making sandwiches, selling them on the NUS campus, sharing the proceeds. This is a partnership. Did you know this is a partnership? Would you have called this a partnership? Okay, Waririra says she would have realized that that is a partnership. Great. Some have got some more thumbs up coming as well. What I'm trying to illustrate is that a partnership doesn't have to be a big business, doesn't have to be ongoing, doesn't have to last for a long time. It can be a once-off. They wanted some money for whatever purpose. They worked together to sell sandwiches. They had a partnership. And their informal partnership is subject to all the laws and regulations regarding partnerships that I am going to be teaching you for the next couple of weeks. So what then is a partnership? A partnership then, the definition we normally use, a legal relationship arising from a contract between two or more, usually a maximum of 20. I'll explain why I say usually later. Usually a maximum of 20 persons who undertake to contribute to a joint business with the object of making and sharing a profit. This isn't the exact definition that's in the study notes. I've made it a little bit shorter. This will also, if you look at that definition of partnership, it will also clarify to you why partnerships form part of Introduction to Law for Accountants. I've told you on numerous occasions that Introduction to Law for Accountants, we've started off with the basics of the law of contract, and then we do different types of contracts. Now, a partnership is simply a specific type of contract. It is a legal relationship arising from a contract, which will immediately tell you that everything that you have learned so far regarding contracts also apply to partnerships. So a partnership isn't a thing as such, like a company is. It is simply a contractual relationship between a minimum of two people. You need at least two people for a partnership. If it's just one person, it won't be a partnership. Will then just be a sole proprietorship. So at least two, usually a maximum of 20, who agree, who contract with each other to contribute something to a joint business with the object of making and sharing a profit. Now, from this definition, you can also extract the requirements. We learned when we started doing purchase and sale, for example, that in order for a specific contract to be a contract of purchase and sale, there are certain requirements. In order for a contract to be a partnership, there are certain requirements. If those requirements are not present, it can still be a valid contract, but it won't be a partnership. So your usual possible question: structured application questions has come into existence. and motivate. Remember, motivation refers to the law, not to the facts. So what are the requirements? They appear in the definition. First of all, a contract between 2 or 20, up to 20 people who undertake to contribute. There must be contribution to a joint business. There must be a joint business with the object of making and sharing a profit. Sharing it. If those three elements are not present, it is not a partnership. If Waririra and Hedvig decided they want to sell sandwiches on campus because they want to collect money to help sponsor the Nust Choir going on tour, would that be a partnership? I don't even know whether Nust still has a choir, come to think of it. We started off by saying they make sandwiches because they want to earn money. They split the money between them. Now, instead of splitting the money, they donate the money to the Nust Choir. Is that a partnership?
No, ma'am, that's not, because they are not sharing profits, or the purpose is not to make a profit.
Absolutely. Thank you, Wadirira. It's still valid, it's still legal, everything, but it is not a profit. It is not a partnership, because their aim was not to make and share a profit. Making and sharing profit refers to enriching yourself, so to speak. If you are doing it for charitable purposes, perfectly legal, you're allowed to do it, everything, but it's not a partnership. So let's look then, before we start looking at the specific requirements, let's just look at some other aspects that you need to know. The legal nature of a partnership. What do I mean by that? I told you that you probably think of a partnership as a business. What is very important is that a partnership is not a separate thing. It is not a separate entity. It does not have legal personality. It is not a juristic person. A juristic person is an entity like a company that is separate from the people inside. It has a separate existence. And you are accountants, so I'm sure you know this. If a company has debts, the shareholders are not liable for the debts of that company. A partnership, however, is not a separate entity. It is not a juristic person. The implication of that is that the individual partners are liable for the debts of the partnership, of the business. So, similar to a sole proprietor, where if your business goes pear-shaped, you might have to end up selling your house. a partnership as well. Business ends up going pear-shaped. You might have to sell your personal property in order to pay the debts of the business. It's important that you remember this. It is not a separate entity. It is a legal relationship arising from a contract. So it is not a thing. It's actually linguistically incorrect to talk about the partnership. It's actually better to talk about the partners. There are certain exceptions to the concept that it is not a separate entity. So there's certain instances where our law does in fact recognize a partnership as an entity. They appear on page 70. The rules of court, for example, provide that if a partnership wishes to institute action, or if somebody institute action against the partnership, it may be treated like an entity for the purpose of the court case. But once judgment has been given, the individual partners remain liable. So just look at those exceptions. Now, a partnership is a legal relationship arising from a contract. Namely, the partnership agreement. Now, this partnership agreement is a contract, just like any other contract. So the contract must be valid. All the requirements for a valid contract must be present, as we illustrated in the beginning of the lecture when I was illustrating that Waririra and Hedvig decide to sell sandwiches on campus. That's a partnership. They didn't sit down and prepare a 10-page document. It does not have to be in writing. If, however, you intend going into a business which involves a bit more than just a once-off selling of sandwiches, you're looking at something more permanent, which is ultimately going to involve more expenses and hopefully a bigger profit. It will be sensible, of course, to enter into a written partnership agreement and decide in advance how are things going to work, how are you going to handle disputes, etc., etc. Always better to do that while you're still excited for the business, rather than trying to deal with disputes if you suddenly become very angry with each other if things didn't work out. So it's advisable to have a partnership agreement, but it is not a legal requirement. It is simply an ordinary partnership. And of course, it has to be lawful. Can't form a valid partnership to sell dacha. It has to be, performance must be possible. You can't form a valid partnership to mine for diamonds on the moon. All those standard requirements must apply also to the partnership agreement. With regard to the provision, the requirement that it must be legal. There's one statutory aspect which could influence the legality, the lawfulness of the partnership, namely Section 35 of the Companies Act. You don't need to remember the precise section if you just remember Companies Act. That is good enough for me. Section 35 of the Companies Act states that should a group of more than 20 persons wish to do business together with the aim of making a profit, they should register as a company. Let's put this down for you. More than 20 people to make a profit must register a company. It follows as a result of this that if a partnership with more than 20 partners they haven't, if more than 20 people get together with the aim of making a profit and they haven't registered a company, that is illegal. It is contrary to Section 35 of the Companies Act. It will be illegal. It will not be a valid partnership. So more than 20 partners is illegal. That's why I said there maximum 20. But why did I say usually? There are some exceptions. Section 35 subsection 2 provides that the Minister of Trade and Industry, it's not called the Minister of Trade and Industry anymore, they've got some different name, but I'm not quite up to date with that. I need to check that for you. May exempt certain professions. For example, lawyers. Lawyers and accountants. So professional partnerships. You get some accounting firms, accounting partnerships, the big five, worldwide, lots and lots, many more, hundreds of partners. PwC, EY, your big five. That is a valid partnership, but it's valid because it's an exempted profession. Law firms, very often, a partnership, but more than 20 partners, and exempt. But otherwise, if you're not, don't fall under one of the exempted professions, a maximum of 20 persons. But Section 35(1) states that want to make a profit. If it's a sports club or whatever, the intention is not to make a profit. There is no limit. On the number of people. Please note that here I'm referring to the number of people, not partners, because it isn't a partnership. So this limitation of a maximum of 20 is strictly for partnerships. If you're a sports club, non-profit making, you can have, there's no limitation, and then certain professions can be exempt. That is why I said there, 2 or more, usually a maximum of 20. Usually a maximum of 20, there are permissible exceptions. Any questions? Okay, let's start looking at these specific requirements. What are the requirements for something to contribute as a contribution? You need to know this uh, also for application purposes. I can give you a case study and ask you, has a partnership been formed? So not this short and sweet structured application, but a more detailed case study where you have to compare the facts and see, was there contribution? Is there a joint business? Is there profit sharing? So contribution, every partner must contribute. It can be anything. As long as it has commercial value. It doesn't have to be money as such. It can be anything. It can be movable, immovable. Um, it can be labor. It can even be knowledge, specific, specialized business knowledge. Um, it can, of course, be money. So anything that has commercial value can be contributed. Partners do not have to um, contribute the same amount. Does not have to be the same or have the same value. One partner can contribute X amount of money and another partner contributes their labor. Both money and labor have commercial value. Very important, and this becomes relevant in numerous other places. Anything can be contributed. The general rule, if it is property that is being donated, obviously not if it's knowledge or labor or something intangible, but if it's something tangible that is being contributed, the general rule is that ownership must be transferred to the partnership. This can have far-reaching implications. I'll give you an example now. The general rule is ownership must be transferred to the partnership unless it is expressly agreed. Remember, expressly doesn't mean in writing, but as long as it has been expressly um, agreed that you are only contributing the use. And of course, this has to be agreed at the commencement, the start of the partnership, not once things have gone pear-shaped. So um, let's use other people for a change. Who have we got here? Maria and Timmy decide to go start a business together. And Timmy's contribution is a car, a vehicle for them to use as a delivery vehicle. Unless they expressly agree when they start their partnership that Timmy will be contributing the use of the vehicle. That vehicle, even if it remains registered on her name, that vehicle will become part of the ownership will pass to the partnership. And when their business eventually dissolves, who was my other partner? Timmy and Maria. Timmy has contributed the vehicle. Once the partnership dissolves, Maria will have a valid claim for half the value of the vehicle. So be aware of this if you go into a partnership, that if you don't want whatever you're contributing to eventually be shared with the other partners, you must specify that you are only contributing the use of that particular asset. If you do contribute just the use, it must still be placed at the disposal. If you are contributing the use only, it must be placed at the disposal of the partnership. So you can't say, I'm contributing my car, and you're the only one that's allowed to use it. If your contribution is the car, all the partners are, depending on the nature of the agreement, allowed to use it. It must be subject to the risk of the business. Which means whatever happens, if the business doesn't work the way you intended, it doesn't make as much profit as you wished, then the chances are that it might be sold to cover debts. It must be subject to the risk of the business. If you contribute, a party uh, who that the contribution be returned to them intact, is not a partner, what will they be? Somebody tell me quickly. So let's say, Pamwe, are you listening? If the two of us decide to go into a business and I say, okay, I will contribute $50,000, but after 6 months, I want $50,000 back. I'm not a partner. What am I?
Evening, ma'am. Does that not make you an investor?
You can use the term investor. I had a more simple, investor is correct. I had a more simple term in mind. I lend you money. I put money, I'm essentially lending money to the business saying I want it back. What would I be? I would give you marks for investor if I ask this question in the test, but that's not the word I was looking for. Come, you're accountants. So the business owes me the money. What does that make me? Lazario? Come on, wakey people, a creditor. Thank you, Jane. As simple as that. As simple as that. They are a creditor. So if I'm saying there's 50,000 to use for the business, but in 6 months' time, I want my 50,000 back, I am simply a creditor. I have made a loan to the business. If my deal was 50,000, in 6 months' time, I want 50,000 plus 20% interest. So I want to make more money. The term investor would also be perfectly correct. Creditor, I'm just getting my own money back, so I'm not really investing, but I would give marks for investor as well. Okay, so those are the requirements for a contribution. It must be a joint business. What are the requirements for business to be joint? All partners must benefit. So if it is simply a case where let's say, Waririra, your hand is up.
Sorry, yes, ma'am. I wanted to, before you continue to the joint business part, may mention that the partners contribute commercial, yeah, like vehicles or machinery or whatsoever to the partnership. So, after contribution, it now belongs to the partnership. So, is that also just expressly made, or how does the transfer come now from the individual to the partnership? Do they just expressly agree on that?
Yeah, well, that will depend, and we will be looking at that later, not tonight, but next week. We've got today, this week, and next week to do Unit 12. So further in Unit 12, we look at the concept of the partnership fund. Now, how does it become the property of the partnership? Depends on the nature, obviously, of the contribution. If it's money that you're contributing, it should be paid over to the partnership into the partnership bank account. Movable things, desks, chairs, whatever, must be physically delivered. Things that require formal transfer, like a motor vehicle or immovable property, a building. There can be formal transfer, like the vehicle is re-registered, so now it's no longer registered on Maria's name, it's registered on the name of MJ Partners. Or sometimes that doesn't happen. That has an influence, and when we get to the partnership fund, we'll talk about that in more detail. I don't want to go into that detail now, it's going to confuse you. But eventually, if the partnership is dissolved and it becomes that, so debts are, when the partnership is dissolved, debts are paid and whatever is left is divided between the partners. Whether there was formal transfer will have an effect on how it is ultimately divided. If the car is still on Maria's name, a creditor will not be able, an outside party will not be able to claim the value as part of the partnership debt. But between partners, the intention is what is relevant, not the formal transfer. So Maria and Jane, MJ Partnerships, Maria contributed the vehicle. She did not specify expressly that she's contributing only the use of the vehicle. But as I mentioned here, let me highlight it for you. The general rule is that ownership will be transferred. So, surprise, surprise, Maria, you contributed the vehicle. You did not agree with Jane expressly that you are only contributing the use of the vehicle. It remains registered on your name. But oh dear, now the partnership dissolves. And despite the fact that it is registered on your name only, Jane will be able to claim her share of the value, even if there wasn't formal transfer. Does that answer your question, Redita? Okay, so these things are important, people, because they can have, from a practical point of view, far-reaching consequences. Maria was blissfully under the impression that she owns this car because it's registered in her name, and the next moment she has to pay $150,000 over to Jane because it was actually partnership property. So if you're going into a partnership that is more far-reaching than selling sandwiches on the NUS campus, you need to sort these things out in advance, because if the express agreement was she's contributing only the use of the vehicle, Jane will not have a claim. Everybody with me there? Okay, so all partners must benefit. It is not a partnership. It's all the profits. The other is liable for the debts. It is not a partnership. So in fact, I can't say one partner gets all, let's put it in abbreviated commas, because it's not actually a partnership. There must be an element of joint decision-making. Not to say that you may not make individual decisions, not to say that you have to, every single time before any decision is made, get together and have a meeting. But there must be communication, there must be joint decision-making. If you can act totally independent, if there's total independence, if you never have to consult with each other, it's not a partnership. Also, that each party is engaged as principal. Contributes to the decision-making process. If the one just follows instructions and has no input, It is an employee. You will be an employee rather than a partner. So that is a joint business, determined by looking at all the surrounding facts. And then profit sharing is fairly straightforward. The meaning of that, the intention of the partnership must be to make and share a profit. So not a charitable business. It must be for personal gain and it must be shared. It does not have to be shared. Does not have to be shared equally. The ratio in which profits are shared, we get to at a later stage in this unit. So one can get, even if one partner gets 90% of the profits and the other one gets 10%, that is profit sharing. That is totally valid. They must at least have the hope of sharing. So an arrangement where Pamwe gets the first 50,000 and Jane and Twainy get to share the rest. And now the business only makes 40,000. So all of that goes to Pamwe. So Jane and Twainy in that occasion doesn't get anything. It remains a partnership because there was an agreement. If it was sufficiently possible, profitable, they would share. There must be a hope of sharing. And then, very important, it is not a requirement that profit must actually materialize. I was changing to American spelling. It is not a requirement that the profit must actually materialize as long as there is a possibility. You are all in the accounting profession. You are obviously realistic about economics. And I'm emphasizing this because I've come across in previous years instances of students actually getting this wrong, where I give them a case study and blah, 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 but eventually at the end of the day, they end up making a loss. And I've had students telling me, no, it's not a partnership because they didn't make a profit. It doesn't suddenly stop being a partnership because the business isn't working. If you've intended to go into a partnership, you had something in mind that could potentially make profit. If it doesn't actually materialize, sorry, bad luck. I'm very sorry for you. That's very sad. But it remains a partnership, and the consequences of a partnership will still apply. Okay, questions? That's how far I'm going to go for today. We have 2 more lectures. We have, according to the course outline, we have the whole of next week also to do Unit 12. Maybe we can get a little bit ahead, but I think I've said enough for tonight. Any further questions?
No, ma'am, not from my side.
Thank you. Am I pronouncing your name correctly?
Yes, ma'am, you are.
Wonderful. Okay. Have a lovely evening. And I will see you next week then. Bye.